to Brick Media Talk, getting legal about digital media. For those who don't know me, my name is Kareem Bland. I'm the traffic coordinator here at Brick, the program department. So I'm the person who put your shows on the air. Okay, me and my colleague Tyrone. We're here with Jeff Hermes, Deputy Director of Media Law Resource Center, Harvard Law School alumni, who's going to talk about copy and fair use. Jeff, how you doing?
Very good, thank you. Well, it's great to be out here with you tonight. I'm looking forward to talking to you a little bit about what I do and the kinds of law that I work with, and hopefully through this process give you a little bit of a better understanding about copyright specifically. Now, copyright is a major area of law for anybody who's engaged in media, and with digital media in particular. So what I'm going to do is walk you through some of the basic concepts, some of the basic issues that you're likely to face either as a content creator or as somebody who's interested in using other people's work. Because there are ways to use other people's work. It isn't completely forbidden. But it is important to know what the boundaries are so that as you go out there, create your own material, incorporate other people's work, you're staying within the bounds of the law. So where I thought I'd start today is with this gentleman who just disappeared from the screen. That's okay. There we go. So this is Samuel Johnson. In 1776, he made the following comment: "No man but a blockhead ever wrote except for money." If you understand this concept, you understand 90% of the policy behind United States copyright law. Because the idea that you need to incentivize the production of creative works, you need to give people a reason to create, is at the core of copyright, and specifically a financial incentive. Now, when our founding fathers were drafting the Constitution, they included this clause in the powers granted to Congress. The Congress shall have the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now, what's going on there? What's the concept behind that? The idea there is just what we were saying before, that in order to promote the development of art, in order to promote the development of creative works, we're going to give people a limited monopoly, a limited ability to control their work, control how it's sold, control how it's performed, control how it's seen by others, control how it's published, limit the ability of other people to take that work and use it. Now, this is a good point to point out the difference between copyright, which is what we consider a form of intellectual property, and other kinds of intellectual property, which I might touch on but won't be dealing with in detail today. Now, as you'll see up here, it talks about authors and inventors, and it talks about writings and discoveries. Now, when you're talking about inventors and discoveries, and you think about people building machines and designing processes, that's when you're talking about what we call the patent law. The idea about controlling and incentivizing the creation of useful machines, useful processes, useful tools. Very different from copyright. Copyright is about creativity, creative works. It says writings here, but this isn't only about writing. It's about music. It's about audiovisual works. It's about sculpture. It's about all the things that we can do to express ourselves in an artistic way. So Congress has been ordered by the Constitution, or given by the Constitution, the power to go out and create these monopolies, create this incentive for authors. Now, how did it go about that? It did it through a statute, a federal law, and created what's known as a statutory right. Now, copyright exists in the United States pursuant to a particular federal statute, a particular section of the United States Code. It lives at Title 17 of the U.S. Code, Section 101 following, so if any of you decide to go look it up, that's where you'll find it. It covers all creative works with a couple of very important exceptions. One of them has to do with pre-1972 sound recordings. We're going to talk a little bit about the concept of the public domain and how long copyright rights last. And we may revisit the issue of pre-1972 sound recordings at that point. But the important thing to take away here is that this is a federal right. It is exclusively the domain of federal law. If you file a copyright infringement lawsuit, you are filing it in federal court, not state courts, not state laws. The reason for this is that copyright is supposed to be uniform across the country. You don't want different copyright laws applying whether you're in New York, in California, in Georgia, in Massachusetts. You want one system which covers all creative works, so that when you're enforcing your copyright rights or trying to use other people's work, you know what to expect. What does copyright protect? Well, very simply, original works of authorship fixed in a tangible medium of expression. And we're going to talk about that in a little bit, exactly what that means. But the idea is that it's creative works which are reduced to some form which is fixed. It's not ephemeral. It's not spoken words which are out in the breeze and gone. It's not ice sculptures. And keep in mind ice sculptures because, again, we will come back to that. So what rights does a copyright give you? In fact, we're talking about a copyright. In fact, it's a bundle of rights. It's a group of different things that the law allows you to do. It allows you to reproduce the work. Copy is in the word for a reason. Reproduction of works, it's about making copies. It allows you to distribute the work, to publish it to others. It allows the creation of derivative works. Now, derivative works are essentially one creative work that's based on another one. Think a film based on a book, a music video based on a song. There may be additional creativity which is added to it in the production of the new work, but it's based on a prior existing copyright. And so when somebody has a copyright in a book, they have some control over the production of things like movies, derivative works. Public performance. So this isn't only about distribution, it's about things like plays and putting on a play so that people can see what, the work that's performed from a script. Public display, so if you're dealing with artistic works, the ability to show it to the public. Digital audio transmission, think about streaming rights. Those are the core rights of copyright. There are a bunch of ancillary ones, and I won't go into much detail about this, but I do want to talk about that first one. It says moral rights in fine art. As I said, copyright is about incentivizing creation. It's about encouraging people to produce new creative works. It is not about the moral rights of the author. It's not about vindicating the author's status as a creator. It's not about, for example, ensuring credit. Notice when you're looking at the core rights which are listed here, there's no right of attribution. There's no right to be named as the author of a particular work. It's not about ego. It's not about personality, except with respect to fine art. So if you're talking about sculpture, paintings, not television generally, not audiovisual works, but the kind of things that you go to a museum to see, yes, copyright creates some special rights there, for attribution, to control, to make sure that a work isn't destroyed before a recording of it is preserved in some way. But in general, it's not about protecting the work that goes into it. It's not about the ego of the author. Termination of transfer. You can give copyrights away. The law allows you to, after a rather lengthy period of time, take them back. Some of you might have heard of a fight over the copyrights behind Superman. This is the concept that's at issue there. The fact that even if you give away your rights as an author, you might have a right to reclaim them later. And then there are a number of other rights which relate to the digital environment. So takedown notices. If, for example, you find your video that you've produced up on YouTube and you didn't put it there, you have a right under the law, perhaps, to send a takedown notice to have the unauthorized post of your work taken down. Digital encryption protections. If you've produced a work that has digital rights management, I don't know if any of you have played around with DRM, but if you have DRM in your work, you have a right not to have somebody try to evade that DRM to make a copy. It's a special right in addition to these other rights. Anti-bootlegging rights. Now, earlier I was talking about fixed works. Anti-bootlegging, it's just what it sounds like. For live musical performances, if you're giving a live musical performance, you have a right not to have somebody make a recording of it, an unauthorized recording. Pre-release criminal protection. So if you're getting ready to release a work, you haven't published it yet, somebody hacks, for example, your studio files and finds your pre-release edition of the new movie you're about to put out and puts it up puts it out through BitTorrent. That's actually a criminal violation, and they can be prosecuted under federal criminal law for doing that. And then there's protection against fraudulent use of copyright notices. If somebody puts that little C in a circle on something, claiming it's theirs and it's not, special rules apply. Similarly, if they take your little C in a circle off your work, you may have some additional rights. But again, for what we're talking about today, we're primarily going to be talking about the rights on the left-hand side of the screen there. Now, speaking of the C in the circle, some of you may have heard the concept that you don't have a copyright, or you can't protect your copyright, or you lose your copyright if you publish your work without the little C in the circle. This thing says, copyright, 2016 by you. That's not actually true. It used to be the case under a prior version of the Copyright Act. It's not true anymore. But registering your work with the U.S. Copyright Office does give you some additional rights and powers. First, it creates a public record of your copyright claim, so that if later on somebody infringes your copyright, you can say, hey, they knew about it, it was a matter of public record. It allows you to file suit for infringement in federal court. You must at least attempt to register your work before you can sue for infringement. It gives you a presumption that the copyright is valid. Now, there are reasons why a copyright might not be valid. Again, we'll talk about those. But the idea here is that if you have a registered copyright, the person who uses your work has to prove your right is invalid. It's not about you proving that you have a valid right. The burden of proof goes to the other person, not you. And then the big stick, copyright damages. The Copyright Act provides for statutory penalties for copyright infringement up to $150,000 per work infringed. Now, that's not the number of copies, but for each work you can receive up to $150,000. And if you hire an attorney to prosecute your copyright infringement action, you can get the other side to pay their fees. Which obviously, if you're an author, you don't have a lot of money, or if you're making media on a shoestring, the ability to have somebody else pay your attorney's fees to defend your rights is a huge, huge benefit. And people who violate copyright can actually be subject to criminal penalties. If you infringe somebody's copyrights for the purpose of commercial gain or for your own private financial benefit, that can trigger criminal penalties. If the value of the work you're infringing is in excess of $1,000, if, as I mentioned earlier, you hack into somebody's database, take their pre-release work and release it online before the author has a chance to release it themselves, that can trigger criminal penalties. And again, if you mess around with copyright notices, that can get you in trouble. So, heavy, heavy penalties if you wind up liable for infringement. Possibly even, the U.S. Attorney General's office in one of its many iterations showing up at your door and arresting you. Something you want to avoid, one assumes. So, does this mean that you're basically out of luck? No. There are lots of reasons why you might be able to use something that somebody else has produced. And in the law, we talk about those as defenses to a copyright infringement claim. Again, a bunch of these. We're going to go through a number of these in detail because these are the important things to understand if you're thinking about using somebody else's work. We'll go through the ones on the left-hand side one at a time. I'll just mention the defenses on the right a little bit. Implied, explicit, or statutory licenses. A license is basically permission to use the work. If you can show that either you were explicitly given permission to use a work or the circumstances reasonably led you to believe that you had a license, or sometimes licenses are automatically created by statute. Sometimes, if you've heard about you know about cover songs, obviously, right? Covers are subject to statutory licenses. The amount you pay for a cover license is defined within the terms of the Copyright Act and various federal regulations attached to it. So you can have permission which is granted by the Copyright Act itself. Okay, independent creation. Copyright prevents against reproduction, copying. It doesn't protect against somebody else happening to have the same basic idea as you at the same time or at a different time and coming up with what's more or less the same work on their own. That's the doctrine of independent creation. The idea being that, hey, look, if we both have a good idea and we happen to create paintings which are pretty similar to one another's, these things sometimes happen. Now, it's rare, and usually if you manage to create a work which is very, very similar to a famous work, you're going to have a hard time proving that you weren't copying it. But but there's a possibility out there. And so, if you create something and it just happens to be similar and you didn't know about it and you can document that your creation process was independent of what somebody else had done before, you may be in okay shape. And finally, there are some statutory exemptions. These probably won't apply for most of what you're doing. These are things like certain kinds of library uses in religious services. But let's go back to the core defenses. Originality. Remember, copyright covers original works of authorship. Now, what does that mean? Works have to have a spark of creativity. It isn't enough that you put a lot of effort into it. You have to show that there was something original, something new, something creative, something that imbues the work you created with, something worthy of protection. It doesn't have to be a lot, but it has to be more than this. It has to be more than a phone book. Feist versus Rural Telephone Service So, Feist Publications versus Rural Telephone Service Company was just that. It was a copyright lawsuit over a phone book. There was, Rural Telephone Service Company was producing books. Feist was producing books. One of them clearly was copying the other because the original phone book had included some fake entries to trap anybody who was trying to copy it, unreal phone numbers which didn't actually exist. So when they saw that this other phone book was using the same numbers, they knew there was some copying going on, filed an infringement lawsuit, went into federal court, went all the way up to the Supreme Court, and the Supreme Court said no. All you do is putting names and numbers in an alphabetical list. There's nothing creative about that. Sure, we understand it takes a lot of work to compile that. You put a lot of money into publishing a phone book. That's not what copyright protects. It's not original enough. Okay, original works of authorship. You have to be an author to sue. So who's an author? Well, there are a couple of different kinds of authorship recognized in the Copyright Act. And again, authors, you think of authors, you often think about writing. It's not limited to writing. It's any kind of creative work. But a single author, it's pretty easy. The person who's working on their own. There's also something called a joint author. Now, this isn't merely when you work with somebody else to produce something creative. Because, for example, you can have the music, you can have the lyrics to the song. Those two things are separately identifiable. Is that a joint work? No. You've got two separate copyrights. You've got a copyright in the tune, you've got a copyright in the lyrics. A joint authorship is one where the creative efforts blend together, and that's why I've got the picture of the paint up there. The idea is that the contributions from the different people meld together and you can't really pull them apart anymore. So, for example, if you're thinking about a motion picture, a lot of people's efforts go into what you see there. You might have the cinematographer, you might have the director. Trying to pick apart what each one of them did becomes almost impossible. That's when you start to think about joint authorship. Okay, and then there's what's known as a work for hire. If you're an employee and as part of your employment you're creating creative works, chances are it's owned by your employer, not by you. The employer is considered the author. You can also have independent contracts which create work for hire relationships. So if you're being commissioned to create a work, it's possible you might have a work for hire. Why is that relevant? Well, let's take a look at this picture. Anybody familiar with this photo? That's Ellen's Oscar selfie, right? Who actually took the photo?
That guy.
Yeah, Bradley Cooper took it. That guy did. Okay, so who's the author?
The guy.
Well, good, yeah, possibly. He's got his hand on the camera, he set it up, he took the photo. It was Ellen's idea to take the photo. She's the one who got all the people together in the scene. So she's providing some creativity. What creativity is Bradley Cooper providing? Hard to say. You can't really tell how much, how much control he's exercising over what's being seen there. He's framing the shot a little bit. But this is just an illustration of why with, a fairly simple action, you can actually have a pretty tricky question about who the author is. This might wind up being a joint work between the two of them, each of them contributing something which results in a single photo, and it's really hard to tell who contributed what. So authorship and ownership can also be transferred by what's known as an assignment. This basically means giving your copyright to somebody else. The law requires certain formalities. If you're assigning certain kinds of rights, it needs to be on a document that's signed by you. And as I mentioned earlier, you might have the right to take it back later. And again, only the author or the holder of exclusive rights in a work can sue. Now, anybody hear about the Happy Birthday case late last year? You know, the big fight over, over whether Happy Birthday is available for all of us to use. Okay. Now, Warner Chappell Music made a lot of money for a lot of years enforcing licenses on the use of Happy Birthday. Eventually, a lawsuit was filed saying, hey, shouldn't this be in the public domain by now? Shouldn't this be out of copyright? This is a really old song, and by the way, where did you get those rights anyway? So, federal case out in California, and a judge ruled that Warner Chappell Music could not establish that it actually owned the rights. It traced backwards the origin of the song, the origin of Happy Birthday, to a song called, I don't know if you can see it up there, Good Morning to You. Good morning to you, good morning to you. That's a fair use, by the way. I'll explain why later. And because Warner Chappell wasn't the owner, wasn't the author under the law, they couldn't enforce those rights. That will presumably be appealed, but that's where things stand at the moment. Okay, so after authorship, we get to requirement that something's fixed in a tangible medium. As I said earlier, written, recorded, sculpted in a lasting medium. It includes electronic recordings. Just because you can't touch a bit doesn't mean that it doesn't count. If pressed, somebody would probably say the tangible medium is whatever storage medium that the bit is held on, but electronic recordings count. What doesn't recount? Spoken words. Sports events. Sports events just happen. There's not a lot of authorship to them. They're not fixed in a tangible medium. Artwork and ephemeral media. So sandcastles, no. Artistic design of the food on your plate at a restaurant, no. Ice sculptures, no. But keep in mind that a lot of performances, a lot of creative works which don't seem fixed might have a hidden recorded work in them somewhere. A play doesn't look like it's being recorded, but there's a script. So even if you don't infringe the performance of the play itself, you might infringe the script behind the play. Choreography. You can get a copyright in planned choreography, the actual design of the footsteps on the floor, showing where people are stepping. Broadcasts. This is this is an important one. The law recognizes that if somebody is simultaneously recording and broadcasting a performance, there is a right in the broadcast, even if without the broadcast it wouldn't be fixed. And there are special rights in live music. Live music is an exception to the fixation requirement because of the concern about bootlegging concerts. There's a special part of the Copyright Act which says specifically you may not make unauthorized recordings of musical performances. It's basically that simple, and the idea is just that, to prevent bootlegging of musical events. Okay, so just to give us an example, I wanted to have you take a look at this. This is a sculpture by a famous artist. It's in ice. It's not, I mentioned earlier, ice isn't a fixed medium. It will melt. Basically, if it melts, rots, decays, otherwise goes away in a reasonably short period of time, it's not fixed in a tangible medium. Now, I included the credit for the sculpture there basically just because I was being nice. But I had to include the credit for the photo of the sculpture because that is a fixed work. And somebody else actually holds that copyright. So, just an example of how, even talking about this, even showing you an example, additional copyrights can creep in. Okay, authorship and fixation work together. This is a woman by the name of Cindy Lee Garcia. How many of you have heard of a short film, very controversial, called The Innocence of Muslims? Okay. So, this was a YouTube video produced by somebody calling himself Sam Basile. I might be getting the pronunciation of the name wrong. And it was, to put it mildly, very, very insulting to practitioners of Islam. The production of the movie resulted in protests and riots around the world. This is just a shot of a protest in Kuala Lumpur to show you how far some of these how far the repercussions of this video went. But going back to Cindy Lee Garcia here, you see, Cindy was an actress. She had no idea what she was acting in. She was invited to take on a small role. Her lines were dubbed over to make it appear that she was accusing Muhammad of being a child molester. Now, this obviously drew some unwanted attention to her, as you might imagine. And struggling to find some way to solve this problem, to get this video taken down, she actually wound up suing Google. Google owns YouTube, so that's why Google gets involved here. And what she claimed was, hey, I'm an actress. I did something creative here. It's a film, it's a recording, it's fixed in a tangible medium. Creative work, tangible medium. I'm an author. I'm going to sue Google for copyright infringement because, to try to get this taken down. Well, she did. And there are a couple of reasons she lost. This was the U.S. Court of Appeal for the Ninth Circuit. It's a federal appeals court out on the West Coast, talking about her claim. And what it said was, that notwithstanding the serious issues she was raising, the actual potential threats to life and limb she was facing, copyright wasn't the right way to go about this. A weak copyright claim cannot justify censorship in the guise of authorship. The Ninth Circuit was very concerned about this idea of actors asserting copyrights in films, because think about as the court is saying here, think about a cast of thousands turning into the copyright owned by thousands of people. Think about what that would mean to publish a work, the number of people you'd have to sign off on contracts. It would become a nightmare. And basically the court said her creative interest here as an author was too fine, too limited. In addition, she wasn't the one who fixed the work. She was an actress, but it was the director, the camera folks, the people working behind the scenes who were responsible for the fixation. So it's not enough to be that the work is fixed. You have to be the one who fixed it in order to sue. And finally, the court expressed, again, great sympathy for the emotional turmoil she was facing and the struggles that Ms. Garcia was having. But copyright is about incentivizing the production of creative works, not censoring them. And so basically the court looked at this and said, you're trying to use copyright for the opposite of what it's meant to do here. And so eventually she lost her claim. Okay, moving on to another defense to copyright. The public domain. How many of you have heard the phrase public domain before? Okay, virtually everyone. This is the idea that sooner or later copyrighted works are no longer copyrighted. They become public property, the property of all of us, the public domain. And this comes directly out of the Constitution's declaration that copyrights are supposed to exist for limited times. Now, there are two categories of works in the public domain, those that have fallen into the public domain over time and those that were never protected by copyright in the first place. That second category is limited to U.S. government works. If a U.S. government agency or a U.S. government official creates work, it creates a creative product in the line of duty, there's no copyright in it. They can't sue you for it if you use it. So those great photographs you might have seen from NASA as it was passing Pluto, probably not subject to copyright. Copies of federal laws published by the federal government, not subject to copyright. Doesn't apply to state governments. So some states do assert copyright in their works, so if you're going onto a state website and looking to take a picture or something that's posted on the site, be careful. Now, the bigger category, things that fall out of copyright over time. Copyrights last a long, long time. So what's up here now are the durations for works that were created after 2002. Now, 95 years from the first publication, 120 years from creation, or if you're going off of the author's life, the life of the author plus 70 years. Why so long? Well, the idea, and remember, no one but a blockhead ever wrote except for money. The idea here is that, The idea here is that people are writing for financial gain, they're writing to make a living, and they're writing for their children. So the survival of this right long after the lifespan of most individuals, and in 120 years certainly after the lifespan of the author, is intended not to protect them but to protect their children, so that there's some benefit which flows on. Now, these rules are fairly straightforward. It only applies to works created after 2002 and published in the United States. If you want to calculate when something falls into the public domain, it's a nightmare, because the law has changed over time. Things have been in the public domain and then been taken out, which creates all kinds of headaches. And it's just really, really complex. Some of the factors which can come into play: what kind of work is it? When was it created? When was it published? Where was it published? Did it have that little C in a circle affixed? You don't need that now, but you used to. And other laws in effect at the time and potentially afterwards. International copyrights, very, very complicated. Sound recordings, many sound recordings are not going to be out of copyright within my lifetime. 2067, that's a long time. Now I mentioned the weird quirk about pre-1972 sound recordings earlier. Now, pre-1972 sound recordings fall in a gap in copyright law. They might actually still be subject to antiquated state copyright laws. I told you copyright is exclusively federal. This is an exception. Some state copyrights never expire on their own. Now the federal law might interfere with that, but basically, if you're looking to try to figure out when something is in the public domain, you might wind up looking at a table with tiny, tiny little text that looks something like this. If you look at this online later, hopefully that image will be a little bit larger. But basically, you're doing a lot of punting and pecking through the law. Usually better to find an attorney who can sort this out for you, because it's really, really easy to make mistakes. Okay, and Congress periodically lengthens terms of copyrights and removes works from the public domain. It could, again, something which is public domain now, in 10 years, if there's a reason, might not be. So what happened to limited times? What happened to this idea that copyrights are supposed to be limited in term? Basically, courts have more or less said that so long as there is a limit, it's okay. Congress can do that, even if the limit keeps moving. So basically, kind of frustrating. My rule of thumb is that, if it was created by somebody in the ancient world, you're probably okay. If it was if it was a painting that's more than 200 years old, you're probably okay. But otherwise, you're better off looking for a legal opinion to help you be sure about what you're doing, what you're looking at. Okay, another core limitation on copyright claims: it's about expression, not ideas. Doesn't matter how creative your idea is, if you don't write it down, if you don't express it in some tangible form, it's not protected. So you can't sue because you had an idea and somebody stole your idea. It has to be because they copied something you wrote or created. Now, there are some important limitations that come out of that. Sometimes there are only a few ways that you can say something. Newspaper headlines. Subway drivers on strike, trains snarled for hours. You can phrase that a few different ways, but really your range of options for how you say that is pretty limited. Tough to assert a copyright in a newspaper headline for that reason. If you get it really creative, you get one of those variety style, rhyming headlines maybe, but short sentences, short expressions, very tough to copyright, because it's tough to separate the expression from the underlying idea, and the one thing you can't do with copyright is block dissemination of an idea. Case from 2011 that raised this issue was called Ho versus Taflov. This actually dealt with scientific equations. There were a couple of researchers who came up with a new model involving the Pauli exclusion principle, which if you know about quantum mechanics you'll understand, but I certainly don't. But the idea being very insightful, very creative, new way of thinking about the universe, entitled to all kinds of credit. But a copyright, no, because the equations were the idea. You can't separate the two, you can't lock up the idea, therefore the expression isn't protected. And this is the big one, fair use. Now, there's a popular saying around fair use. This is it. Fair use is anything I want to do with somebody else's stuff. Copyright infringement is what you want to do with mine. That comes out of a lot of behavior I've seen on the internet, people grabbing material to use and then getting upset when somebody grabs their material in return, and the sort of general free-for-all. There's a lot of confusion around fair use. People think that nonprofit uses are fair use. Not necessarily the case. The internet is based on linking. You're hyperlinking to other people's content all the time. So what's the difference? Actually, there's a significant difference. And a lot of the time you can get away with it. It's a pain in the ass to file a copyright infringement lawsuit. Does that mean you're not infringing? No. Does that make it what you're doing a fair use? No. It just means you get lucky. You might not. So in reality, fair use is a judge-created legal doctrine. It's actually, again, in the Copyright Act. You want to see what fair use is, you can go look it up. It's 17 United States Code Section 107. It's heavily invested with First Amendment values, rights of free speech, and it protects copying for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. All of those things kind of have an interesting theme to them. The idea about informing the public, the idea about getting new information out there. It is a balancing test that takes into account 4 factors. These are the factors, they're in the body of the statute. None of them is determinative on their own. The purpose and character of the use, nature of the copyrighted work, amount that you're using, and the effect of what you're doing on the market for the original work. Now, actually, one of the world's leading authorities on what fair use means is here in New York. It's a judge by the name of Pierre Laval, who sits on the U.S. Court of Appeals for the Second Circuit. To the extent that I'm talking about what fair use means, a lot of it is coming from him. I just thought it would be worthy of a mention because he's a very, very bright guy. Okay, so purpose and character of the use. What does this mean? So we're talking about how you use somebody else's work compared to how they used it. Now, what the court is looking for most of the time is what's known as a transformative use. You're doing something new and different. You're trying to, express some new idea. You're trying to maybe comment on, comment and criticism we mentioned earlier. You're trying to comment on the original work, so you need to use portions of that work to make your comments. You're trying to criticize a work. It's hard to criticize something without showing what you're criticizing. And so the idea here is that by allowing these kind of transformations of the original work, these new formulations of it for different reasons, that supports the purposes of copyright to increase the flow of information to the public, increase the flow of new creative works. That supports a finding that your use is fair. Now, this can also include whether your use is for-profit or non-profit, but that can be very misleading. Not every for-profit use of somebody else's work isn't fair use. Not every non-profit use of somebody else's work is fair use. Why is that? Well, it's really easy to imagine a non-profit use of somebody else's work which destroys their work without really contributing anything to society. If I go and copy an album and start selling CDs or start giving away CDs not selling, let's assume I'm giving them away, and giving away CDs on the sidewalk, I'm not benefiting personally. It's not a for-profit use, but nobody's going to buy a CD that they can get for free. And so that's a good example of a non-profit use which is really hurting the original author and not doing something new or different. So some of you might have heard of parody and satire, 2 different things. Parody is a form of comment on a work. Most of the time you're making fun of it. You need to use the original work to comment on it. You need to use the original work to make a parody, otherwise nobody knows what you're talking about. Satire is a different kind of thing. Satire is when you're trying to make some kind of a point, and you may use somebody else's work as an example, but you're not really talking about that work. So, an example, if you're making a parody of Star Wars, you're making fun of Star Wars. You may use some of the characters, you may twist them around a little bit. You may, bring out facets, you may make a whole lot out of Luke and Leia having that kiss. But the idea there is that you're commenting on the original. If you're commenting on evil in the world and you decide that you're going to dress up one of your, dress up a politician like Darth Vader. That's not commenting on Star Wars. That might be satire. It might be comment on public events. It might, there might be a purpose for it. But it's, but you're using Darth Vader as a shortcut for, for the idea of evil. You could come up with some other creative way to do that. It's not as necessary that you use that image, and so you might have a weaker argument that that's a fair use. Okay, key case here involving the song "Pretty Woman." How many of you are familiar with Roy Orbison's version of this? Okay, there you go. How many of you are familiar with Two Live Crew's version? Okay, two very different things. Two Live Crew very definitely doing this for profit. U.S. Supreme Court heard this one and said, hey, you know what? It really is a comment on the original. It's really, it's really a transformation of what the original, of what Roy Orbison's original song was doing. We're going to call that a fair use. It doesn't matter that they're making money off of it. It's creative enough. It's adding something new. It's using the work as a basis for a different kind of commentary. And so they actually, and so they succeeded in fighting off a copyright lawsuit. Okay, nature of the copyrighted work. This is just really brief. In order to determine whether a work is whether your use of somebody else's stuff is transformative, does something new, obviously you have to compare it to the original. So you have to take into account the nature of what the original one was. At this point, it doesn't really matter how creative your use is. It doesn't really matter, whether you're doing something, whether you're doing something brand new or mildly creative, or whether the original is mildly creative. But the idea being you have to take into account both works to make a judgment. Okay, the amount used. So there are lots of different ways you can use somebody else's work. You can take short snippets of a song. You can take a still frame from a movie. You can take an excerpt from a book. Now, how much you use can factor into the fair use determination. Generally, if you use as little as possible to accomplish your goal, you've got a better argument for fair use than if you're taking more of it. Now, this entirely will depend on how much of the work, or the nature of the work you're using, the nature of your use. It ties into the other factors, and I'll show you an example of that in a moment. But generally, the more of the work you take, the more likely that somebody can simply take your work and substitute it for the original. So if you're doing, say a review of a short film, and you include the entire short film as a basis for your review, somebody can just watch your show, see the film and your review. They never have to go see the original or pay the original creator. That's a problem. And then there's the final factor, the effect on the market. Remember, copyright is about incentivizing authors. If you interfere with the incentives for the original author by hurting the market for their work, how much money they can make, you're going to have a tough time on a fair use analysis. So, going back a while to President Gerald Ford and his pardon of Richard Nixon. So Harper and Row book publishers published A Time to Heal, the autobiography of Gerald R. Ford. There was one portion of that book that anybody cared about, and that was, why did Gerald Ford pardon Richard Nixon? What was going on in his mind, in his words? Now, the magazine The Nation published a very brief excerpt of that book, but it was exactly the section that talked about why Nixon was pardoned. Copyright infringement action. The Nation says, hey, we only used a tiny piece of this. Well, it was the heart of the work, as the Supreme Court called it. By even publishing that small snippet, they so undermined the market for that book that the court held that it was not a fair use. And then there's the fifth factor. I know I said there were four, but there is a fifth, and it's an important one. And that very simply is, do you make the judge laugh? If this is actually really true. You need to take into account the fact that when you're arguing before a judge, these are human beings. If they think what you've done is clever, neat, funny, chances are you'll have a better shot at a judgment in your favor here. I love this example of it. How many people are familiar with what's on the screen here? Okay, at least one. The video, the left one is a still from a video called What in the Butt by an artist named Samwell. The right is the South Park parody using the character Butters. And the folks behind the one on the left were not best thrilled with the folks at South Park, essentially copying the entire song and just having Butters performing it, using very similar staging, very similar imagery, and more to the point, a lot of people finding the second one a lot more funny. And so they sued, and but the court went through the four fair use factors, said, hey, this is really different. You're parodying it. You're making a commentary. Changing this from being an adult to being a kid in a story that's commenting on bad things people think about children actually has kind of a social purpose, that kind of stuff. But the undercurrent was the judge thought it was funny, and found that it was fair use in 2012.
It also reminds people of that song, like so they'll go look at that video to see.
That's actually an excellent point. Sometimes your use of an original work can help the market for an original. Yeah, I mean, you can actually see that in a lot in what's known as aggregator services. So there are services which just go and collect headlines from other newspapers, collect links, and forward people to original news articles. They often will use clips from a news article or something along those lines to do it, but providing that link can help the original work by helping people find it.
So that could be an argument in your favor if you infringe on someone's copyright, but by doing so you actually increase their sales of their original work. That could work in your favor.
It can. It does get complicated because you have to figure out what this exact market is,
right,
and whether the way in which you're helping them exploit the market might actually interfere with how they're trying to present their work. So, for example, I mean, I might help a lot of people find a news article, but if the news article was intended for a limited subset of the audience, and now I'm making it popular, so there's no cachet to knowing about the article. You can get weird kinds of contours there, but it is a great argument, and it's made in a lot of fair use cases. I'm not hurting, I'm helping. But you better be able to show that you actually are helping. I mean, it helps if you have evidence, if you can show an uptick in the hits on YouTube, following the broadcast. I'm sure that this video got a lot more hits after the South Park episode aired. Other recent issues which are coming up if you're into photography. A case called Cariou versus Prince. Patrick Cariou, did some very, very creative work. Richard Prince is is a self-styled appropriation artist who takes other people's work and messes around with it and then calls it his art. Creatively enough, one might say, but this is an example of Cariou's photo is on the left, Richard Prince's modified photo is on the right, blacking out the eyes and mouth of the man in the photo and adding a guitar. Nobody was really sure which way this one was going to go. This kind of failed the laugh test because it looked like, a very creative photograph that somebody put a lot of work into getting. There was actually a lot of sweat of the brow that went into this photo series. And then, and then the changes seem relatively trivial, relatively minor. Now, Prince, Richard Prince, not to be confused with the other Prince who likes to file or has been in favor of copyright enforcement. But Richard Prince is actually pretty good at articulating why what he's doing is artistic, and so what the transformational use was here, and he actually won on appeal at the Second Circuit here in New York.
Yeah, because Ruby McCure does the same thing.
Appropriation art is very controversial, sort of across the board when it comes to copyright, and part and parcel of doing the work is the ability to justify what you're doing. If you can't justify it in artistic terms, there's a good chance you'll have a hard time justifying it in legal terms as well. This is from a production on Broadway called Hand to God. And as part of this production, there's a scene in which the gentleman depicted, I believe, and his sock puppet. I don't think it's Lamb Chop. From the back, they look kind of similar. Carry out Abbott and Costello's Who's on First routine. Very definitely a copyrighted work. And the current holders of the copyright in Abbott and Costello's Who's on First, again showing you how long copyrights can last, filed suit because they essentially performed most, if not all, of the entire routine as part of the play. Now, the Southern District of New York, the trial level federal court in New York, kicked out the claim, saying, no, that's fair use. Nobody's going to the play to see Who's on First. It's used in Who's on First to make a point. As I understand it, the scene involves this person carrying out the Who's on First routine and somebody not realizing that he didn't make it up. And so there's an interchange between characters that relates to, you know, the other person's ignorance of what's going on in front of her. And, you know, and so it's part of the story. It's integrated into it. And you need to use a recognizable work to carry that out, something that people in the audience will know the person on stage didn't create, or else the dramatic point falls flat. And again, really no effect on the original market. You're not, I mean, nobody's going to go see the sock puppet version as an alternative to hearing Abbott and Costello do it in the radio version or seeing one of their live versions. This is a recent issue involving photographs. Judge Jeanine Pirro's Facebook feed on Fox, around about September 11th, posted this photo. Anybody recognize this photo? Well, the one on the left, the one with the firefighters with the flag. Yeah, exactly. And it's North Jersey Media owns the or at least is managing if it doesn't own the copyright in that photo. And essentially said, hey, you know, this is a news photo. You're using the photo to convey exactly the same sentiments as the photographer that took it. This isn't transformational. You know, we make lots and lots of money licensing the use of the use of that photo. Fox, you know, you who are standing behind Judge Jeanine Pirro here, you should pay up. Fox said, well, you know, actually, this isn't your photo. This is a modified version of your photo, as you can see in the photo on the right. We, you know, because we superimposed the very similar Iwo Jima image behind it, and so what we're doing here is commenting that the photo in front, the 9/11 photo, is similar to the photo in back, for, you know, the Iwo Jima image, and so really this is juxtaposing historical eras and commenting, etc., etc. A district court judge here in New York looked at that and said, nah, not fair use. The point you're trying to make is kind of hackneyed. People have made the comparison between the images before. You're using it to promote your show. There's really no new message here. So this is actually about to start a copyright trial here in New York to determine whether there are any other defenses and whether this will be damages. So this is a live issue, which is currently pending, as to whether this is really fair use or not. Anybody in the audience have a feeling as to whether this is fair use?
I think it's fair use.
Okay. I mean, a lot of media lawyers are torn on this one. I mean, the idea, you know, normally when you're talking about commentary, it shouldn't really matter whether or not whether your comment, your criticism, your transformation is new. It's not about whether you're saying something that hasn't been said before. It's about whether you're doing something other than the original.
Yeah, because I was wondering if they're commentating, right, and they got those two arrows. Sorry. If they're commentating and they have those two arrows, then that means that they're actually trying to show you something in the picture.
Well, I should say the two arrows I added so that people could.
So they forget what I said.
Sorry for misleading you on that.
You misled me.
I put the arrows in there because it was a little hard to see.
But I'm glad you brought that up. If the creator of the second piece put those arrows, does that make a difference? If they're making a statement in some sort.
Well, I mean, it might make it a little more obvious that they're trying to compare the two, but the comparison is there anyway. So I don't know that that would make a huge difference in context. The it's sort of interesting. Every photo which I've used in this presentation is either licensed or subject to fair use. And I'm arguing fair use for my use of this because in order to talk to you about what the issue is, I have to show you what the photo is.
That's what I was thinking, and that's why I mentioned the arrows, because I was like, if I'm commentating and I'm trying to tell you something about what you see, then I have to show you.
Right, and so my arrows for these purposes quite definitely support fair use.
Yes, thank you.
Okay, so fair use balancing test can be very complicated, lots of factors. What if you can't make out a fair use defense? You need a license. You need permission. You need to go out and find some, get authorization to use it. Most important rule, don't assume that just because you can find something on a Google image search that you can use it. Just because it's online doesn't mean it's free to use. Just because you can control C and copy it into your own work doesn't mean that you have authorization to do that. This happens all the time. Reporters do it. Media organizations do it. It seems so simple. You're on a rush deadline. You need to illustrate your story. What's the big deal? No one ever gets sued. Well, people do get sued.
You'll be the lucky bastard.
Yeah. So, licenses, though, can be hard to get, especially with online content. Finding the actual owner of something you find online to ask them for a license can be really, really tough, especially if you find it on Google image search. And they're not required to give you a license you can afford. They can control the market for it. But trying and failing to get a license for a work you have a justification for using can actually help your fair use claim. Because if you can show that your use was not part of the existing market for the work, because no one who is doing what you're doing could afford it, you might be able, that might help your justification for why you needed to use it, and that really the effect on the market might be minimal because there was no market for your use at your price point. It's not a slam dunk. But even if you're planning on eventually going for fair use, trying to get a license can help. Now, there is a lot of stuff which is easy to find. There are services which provide affordable licenses or free licenses. Getty Images, wire services if you're looking for news content. Creative Commons. Does anybody know what Creative Commons is? Have you encountered that before? Okay, a couple of people. Creative Commons is just a licensing standard which is free for anybody to use. They are prepackaged copyright permissions which some people have hooked onto their work to allow people to use them for free. And there are search engines which just look for Creative Commons works. You can use Google search to search specifically for things that are open licensed in this manner. There are different kinds of licenses. Some of them say you can use it, but you can't use it commercially. Some of them say you can use it, but you can't change it. Some of them say do whatever you want with it, just you have to tell people that I'm the one who created it. And so earlier when I showed you the photo of the ice sculpture and I had the name of the person who took the photo, that's because it was a Creative Commons licensed photo and I was responsible as the person using it for telling you who created it. Now, again, it's never as simple as you think. And just because somebody puts a license on something or puts a Creative Commons logo on it doesn't mean that they necessarily have the right to do it. And so you still have to use common sense. As with this image posted by a Flickr user. Okay, I found this on Flickr. It purports to be under a CC BY license. That's a Creative Commons attributions license that says, oh, yeah, use it. All you need to do is hook my name onto it. Okay. Hopefully it's obvious why this is a problem. I mean, can anybody spot at least 3 reasons why you should be wary of this?
Well, I see a copyright logo at the bottom.
That's probably the biggest one right there. Now, does this mean that this person doesn't have the right to put this up? Probably. You can't assume that. I mean, I have no idea who Mark Anderson does, and neither do you. Could he be the original artist who somehow got his work back from Marvel? There's a remote possibility, but chances are no. And so if you roll forward assuming that that his attempt to give you a Creative Commons license is sufficient, you're going to run into you're probably going to run into some problems. So, use some common sense. Look for those red flags. If something looks like it was professionally created or studio created and you're finding it in a context where it shouldn't belong as a free work, it probably isn't. So again, just you can't check your brain at the door when you're looking for work to use. So some best practices to avoid this kind of stuff. Know where your work is, know where the content is coming from. If you can't identify who created it, you can't get a license. Anything, you're proceeding at your own risk. If if you find something that you can use, try to obtain a license or be able to articulate why your use is fair. Lawyers can help you do that, but it's, the idea of having a narrative in your head for why you need to use this work or why this is within the scope of permission you've obtained is very, very important. Because even if you have a lawyer, if you get sued, sooner or later, it could be you sitting on a witness stand trying to explain yourself. So you need to have some idea of what to do in that situation. Excuse me, little bottle. So that's trying to avoid being sued by other people. What if you want to license your own work? You've put a lot of effort into something. You've got a creative work. You're looking to make some money on it. You're looking to get it published. I mean, you hold a copyright in something as soon as you create it. As soon as you create that, that original, that work of original authorship in a fixed medium. And unless you self-publish, somebody else is going to need a license from you to do it, because otherwise they'll be infringing your copyright. Now, usually that's under a contract. This can arise in a number of different circumstances. If you're a if you're a freelancer, ordinarily you'll have a freelance agreement with a newspaper. Excuse me. If you're part of a film production, you'll probably sign some document at some point which gives any intellectual property rights you have in the work to the producers of the film. In online media, it's often in terms of service. If you post something to YouTube, you better believe there's a license in those terms of service you may or may not have read, which allows YouTube to be distributing the work in the way it does and probably doing some other things with it. One interesting thing to do, even if you don't read terms of service front to back, or those, or the privacy policies or the things on the websites you use, try going through the terms of service and just finding the copyright terms. Look for the things that talk about what permission you're giving somebody to use your content, whether it's your tweets, your Facebook posts, whatever. It's a very interesting exercise, and it'll help familiarize yourself with what this kind of language looks like. Two basic types of licenses, or two basic types of transfer of copyright rights. There's a license and an assignment. A license is just permission. You can shape that permission how you want. You can limit it in time. I give you the right to use my work for a year. You can limit it in terms of use. I give you the right to use my work in a published compilation of photographs, but not as part of an audiovisual work, not as part of a movie. And ownership remains with you. So you continue to be the author of that work. An assignment is the opposite. That's an actual transfer of the ownership. You give up all your rights. The other person effectively becomes the author, and you yourself can infringe your own work if you keep using it without permission. So it's very important when you assign your rights away that you know the conditions under which you're doing it. That's actually bitten some musicians in the behind in the past when their rights went to their record company, and then they tried to make later works that sounded a little too much like their earlier work. There have been a few cases like that which, resulted in, shall we say, at least some complications for the artists involved. A couple of things to take a look at. I'm not going to read this out, but just, types of licenses. A non-exclusive license. I give you permission to do something with my work. I might give somebody else permission too. Non-exclusive. It will usually refer specifically to a license. It will usually use the words non-exclusive. In contrast, an exclusive license. I let you do it, and I say I'm not, and I promise I'm not going to let anybody else use my work. or at least not for the same purposes for which you're using it. Or I give you the exclusive rights of distribution, or one of those limited copyright rights we talked about earlier. And it may or may not say something like the language at the bottom here, explicitly telling you that you can't compete with the exclusive licenses, but an exclusive license is just that. It excludes everybody else from using the work, including the author. But you still own the work. It's important because you can eventually get it, you can still control it. An assignment, that's different. Sometimes it will, sometimes it will use the language of work for hire. Sometimes it will just talk about a transfer. You can cancel a transfer of your copyright. I mentioned that toward the beginning of this talk, but you don't have the right to do that for a long time. So if you're assigning your copyright away, you have to be prepared that you're going to lose control of it for a very extended period. And so, there are other variations here. It's important to read the language carefully. If somebody presents you with a contract, again, a lawyer can help. You can have exclusivity changing to non-exclusive later, renewals. I can assign you my copyright, and then you can give me a license back so that I can continue to use it for limited purposes, even though you now own it. You may see these as well, warranties and representations. If you're assigning the copyright, they're probably going to want you to go on the record promising that you actually own it. It's a way for them, if they wind up getting sued by a third party who actually owns it, they can come back to you and say, hey, you promised us X, Y, and Z. You promised us that this was actually yours. Negotiating these agreements, again, a lot of times it's take it or leave it, but if you do get a chance to negotiate a license or an assignment, you should have an attorney help you. Okay, so a lot of stuff, a lot of very complicated principles. What do you do if you do need a lawyer and you do need help? It's important to look for a lawyer who actually knows about copyright law. You can get in a lot of trouble if you haven't, you have your cousin who's an attorney who isn't a copyright lawyer try to help you out, because there's a lot that's counterintuitive in the law. It's always, always better to get help before you try to do something rather than trying to fix it later. Easier to ask forgiveness, not in this context. Asking for forgiveness later can get very, very expensive. So just a few names I wanted to call to your attention. Law school legal clinics are a great place to find some low-cost help. Usually clinics are free. Depending on the arrangement, there may be a small charge, or they may ask you to pay expenses related to the work they do for you, but not pay for their fees or time. But a lot of them will just do it entirely free, depending on the nature of the work. And this can be, this can often be things from negotiating a contract to helping you understand whether your use is likely to be considered a fair use. In some cases, actually helping to represent you if somebody starts threatening you with an infringement lawsuit. So Brooklyn Law Incubator and Policy Clinic, staying local, they're a great clinic which focuses on sort of new digital media kinds of projects. If you're into indie film, Cardozo has an indie film clinic. NYU has its technology law and policy clinic. If you're dealing with First Amendment rights and media and sort of news gathering and you run into issues there, Yale might be able to help you with their Media Freedom Clinic. And if you're in digital media, Harvard Law School has a cyber law clinic, which, though they're up in Massachusetts, nevertheless can help with some projects here in New York. There are also nonprofit organizations that do this kind of work that, outside of the academic sphere. New Media Rights is a group out in California that produces all kinds of resources for folks who are involved in producing digital media. Volunteer Lawyers for the Arts has wide-ranging services. These are literally just what they sound like. Volunteer lawyers willing to help with any issue that an artist comes to them with. The Electronic Frontier Foundation. If you're battling over free speech rights online, these are good people to know. Reporters Committee for Freedom of the Press. If you're a reporter and dealing in news production and you have an urgent issue, they have a hotline. And finally, there's my group, the Media Law Resource Center. We are a trade organization for media attorneys. Although we don't help clients directly ourselves, we can put you in touch with some of the top attorneys in the country who work on these issues. Now, our attorneys generally expect to be paid, but if you can't find somebody who can help you for free and you need somebody who really knows what they're doing, not a bad place to come for help. So that's it for me. Thank you.
Thank you, Jeff.
Thanks. So I'm sure I blew past my time, but
Yeah,
if there
we
are
started late, but it's okay.
okay, but if there are questions, I'm more than happy to answer them.
Okay.
One caveat I will give. I saw some hands shoot up. One caveat I will give before we start is that although I am a lawyer, I am not your lawyer, and as a result, I can't advise you on specific situations. So, so with that limitation, I'm happy to answer questions about what you've just heard, other things relating to digital media law, and
okay.
go from there.
If you have a question, we have a mic right there. Just stand up.
I just have one question. Tell me about the poor man copyright. Does that exist or no?
The poor man's copyright. Now, the way I've heard that relates to essentially putting a copy of a work in the mail and
No, the original.
putting the original in the mail and having it come back to you, so that you have a post-dated copy of when the work was created. Well, date of creation is important. It helps to show when you created a work, so that if somebody comes along later and claims that it was their idea, you can show that you did it before them. Does it give you legal rights? Not in any technical sense. If you're worried that somebody is going to copy you and you just want documentation of when you created something, then sure, it's a way of, if you can read the postmark, which I often can't, but it's a way of dating something with a seal. I don't know how far you'd get with the idea that, it's an official government record because it's the post office who did it, and even the post office can make mistakes. But, there's no reason it couldn't help. But again, it's not what I'd hinge my copyright defense on.
I just said, until you can do it, is that a way to, kind of safeguard yourself? Because if, say you come up with something on the fly, because you said you can't make an idea, you have to make an idea into an expression.
That's
you have
right.
to write things down. But if I don't have the money to copyright what I just wrote down, am I able to mail it back to myself and hold it until I'm able to do so?
And again, only to the extent that it documents in some sense when you created it.
Right.
You are always much better off registering a copyright
Right.
with the U.S. Copyright Office.
Right.
That is an official official record documenting when a work was created, and that's the trigger that gives you that whole bundle of rights for enforcement that I mentioned earlier.
Okay. And then you made me come up with another question. If you're filming something, you're recording that, do you take that recording and then give it to the copyright people, give the SD card or whatever, give it to them, and then what do? Copyright this SD card? How does that?
Well, you do need to submit a copy of the work to the Copyright Office to register it. The form it takes varies depending on the nature of the work. With something like a film, you would probably submit it. I don't know what their capacity is at the moment for taking digital files, whether you could submit it
Right.
digitally or whether you need to submit something like a DVD.
Okay.
But yeah, you'd need to get them an actual copy of it, which goes into their records. And so if somebody wants to go see what has been copyrighted, they can actually go to the Copyright Office and find out.
Okay.
Well, I have one question.
Sure.
Piggyback off of that. Is it true that once you create, video media, and you put the copyright logo at the end of it, it's already been copyrighted?
It was copyrighted before you put the logo at the end of it. You get your copyright rights as soon as you create an original work of authorship in a fixed medium. You don't need to put the C in a circle on it. To the extent that you put the C in a circle on it to let other people know that, hey, I'm claiming a copyright, that's great. But you don't need to for the legal rights to start to accrue. Oh, and you don't need to have published it either. That's an important thing. I can write the novel which I keep in my desk drawer. That's still subject to copyright.
So my question is regarding website use.
Sure.
So I see, on my website, I have the little C with the circle on it, and I've put that there. Well, actually, it just says copyright. So how does that apply to websites? Like when you're creating like blogging or when you're taking completely, new pictures or recipes, how does that work?
Well, now I understand your question to be referring to, if you put a copyright logo at the bottom of a website, what is it referring to? Is it everything on the site? Is it
Or when you see it on someone else's
right?
website, it's like, yeah.
Generally, to the extent that the copyright notice has any meaning, it's what a reasonable person would understand it to be referring to. If I saw a copyright notice on a website, I would be assuming it's claiming copyright in the entire website. It's not impossible for websites to have notices at the bottom which say copyright blah blah blah, except for items A, B, and C, which are copyright somebody else or used or used by permission, is the phrase you often see, which is indicating that there's licensed content there.
Okay. So for, let's say, like you wanted to copyright things that are on your website, would you have to print that out or like copy the web pages? Like, what would that process be like?
It changes depending on how the Copyright Office is taking submissions. It used to be that you'd print it out and then submit it that way.
Okay.
But keep in mind that registration gives you these rights. You don't need to register right away to have these rights, but you need to have registered before somebody infringes if you want to sue for statutory damages generally. If all you care about is stopping them, you can, if somebody infringes, you can probably register, file a lawsuit, and get an order from the court telling them to stop. So it's not always worth it on a rolling basis to register everything you create, and that does get expensive. Most media outlets will make a judgment call as to what they're going to register on an ongoing basis.
Okay. All right, great. Thank you.
Thanks.
Any other questions before we wrap this up? Oh, someone's coming now.
Hi.
Hi.
My question is about, is it licensing that I would need to be able to use open source code if I want to write a software pack, if I want to create something?
So sure, software is sort of a subcategory of creative work. Software is generally subject to copyright, so we are in the right field. And there are open licenses that relate to software which are different from Creative Commons. So, and those can vary, but the idea is basically the same. If you find a piece of software that is open licensed, generally the terms of the license will be available with the software, and that will tell you what you need to do. An open license is different from other kinds of permission in that they essentially give permission to the world. If you find something that is legitimately open licensed, you don't need to go find the creator and get permission. They've already given you permission by opening it up to people under the open license.
Okay.
But it is a contract. You are limited to what the open license tells you you can do, but you're accepting the terms of that license by using the work.
Okay, so I'm accepting license by using the work, and I'm using that work to create something.
Yep.
Say a web page or
Sure.
a website, for example. And then my website is an e-commerce site to be able to create, for profit. That's okay.
It entirely depends on what the terms of the open license are. If the open license says you can use this code for commercial purposes, then maybe it is okay. If it says you can only use it for non-commercial purposes, then it might not be.
Okay.
Again, just because something's open license doesn't mean that it's unrestricted. You need to look at what the terms are under which you're using the code.
Thank you.
You're welcome.
Okay, one more question. This will be our last question for the evening.
Hi, good evening. I wanted to know if I wanted to have a show online, a live show to talk about different topics or sometime invite people to talk. Must I pay a licensing agreement with the federal government or must I pay, I don't know if other people that maybe have the idea before I did, I don't know if they patent it or...
Well, ideas aren't protected by copyright, only expression. So just because somebody had a similar idea for a show isn't necessarily going to stop you. There could be other kinds of intellectual property which come into play, but but just assuming that, based on your question, that you had an idea for something you'd like to do online, a form of chat show, say,
Yes.
and you want to cover particular topics.
Yes.
Just because somebody else is doing a chat show on similar topics doesn't prevent you from doing it. And you don't need a license from the government to do that. All you need is the resources to create that work, and then you can post it online.
Okay. All right. Thank you so much.
You're welcome.
Appreciate it.
Okay, thank you very much. I hope this was informative. I hope you got something out of this, and keep creating great media and share it to the world. Thank you.
Thank you.